Hi, it's Mike Bayer with Free Speech Media in Toronto, Canada. It's my pleasure to welcome Eugene Volokh, Catherine Ross, and David Hudson for our discussion today regarding the BL Mahanoy Area School District case. In a landmark decision on June 30th, 2020, a federal appeals court ruled that public schools cannot censor students' off-campus speech based on a fear of disruption of school activities. After the appeals court ruling, the school district appealed to the United States Supreme Court, and the court granted the district's motion to hear the case. Oral arguments will be held on April 28, 2021. Eugene Volokh is a professor at UCLA School of Law, where he teaches and writes about First Amendment law. He is also the co-founder of the Volokh Conspiracy, a blog in which many law professors write about legal issues. Catherine Ross is a professor of law and Fred C. Stevenson Research Professor of Law at George Washington University Law School and author of a forthcoming book, A Right to Lie, Presidents, Other Liars, and the First Amendment. David Hudson is a scholar and author, co-author, or co-editor of more than 40 books. For much of his career, he has worked on First Amendment issues. Welcome, everybody. Let's begin.
The BL Mahanoy case is of interest to all of us. Let's start with what is it and why is it important?
Catherine, you want to take that?
Sure. The speech of students in school is covered by a special First Amendment doctrine that is adapted to the special environment of the school, the fact that we have compulsory schooling, and the civic mission of the public schools, that it's very important that they do their job in educating the children who will be future citizens. They are citizens already, but active citizens and workers. And in light of that, the Supreme Court in 40 years ago crafted a special doctrine known as the Tinker Doctrine that says that schools don't have to accord students all the First Amendment rights that they would have outside the schoolhouse gates or that adults have in the world at large. And instead, schools can regulate, meaning punish, forbid and punish, student speech that the school reasonably anticipates may lead to a material disruption, filling in brackets, of the school's educational mission, or interfere with the rights of others. And after that, the Supreme Court narrowed that rule by making a number of exceptions that impose different standards for different circumstances of school speech. And the issue in this case is that the school district punished a girl for her off-campus speech. And in this case, she was a girl who'd been an aspiring varsity cheerleader since fifth grade. And she was on the junior varsity team cheerleading group in high school. And she tried out to make varsity and she didn't make it. And she was very upset. And being a teenager, she expressed herself. And she was with a friend in a convenience store, and they did a disappearing snap that 250 people who she was friends with, many of whom, of course, were students at her school. That's where kids have their world. And she used the F word to F cheerleading and F this and F that, and a few other choice phrases expressing her dismay. And this reached the school. And she was cut from junior varsity for a year, which is a serious penalty. It's not like being expelled from school, but not only was it very hurtful to her, but these extracurricular activities are very important in college applications and other things, and you're standing in the community. The school admitted that she was an honors student. She wasn't a big troublemaker. And so her parents challenged this penalty. And that's how these school speech cases get to court, with the parents' full support. And the lower court, the trial court, actually took evidence and concluded that the school had overstepped its powers and violated her rights. And the case went to the Third Circuit on appeal. The Third Circuit has had a number of these social media off-campus speech cases, and it has been very protective of student rights. But it and drawn lines around these cases and overturned each of the penalties the schools have imposed over the years. And this time it came out much more clearly and said the special legal standards for school speech do not apply off campus. It didn't reach the question of whether BL's speech would have satisfied that in-school standard because it had already said the school can't punish it based on any school jurisdiction and certainly couldn't apply school speech standards. Her speech is entirely protected under the First Amendment. But they didn't need to ask whether this incident would even have satisfied the standard in school. And it seems very clear to people who understand this branch of law that the school would have violated her rights even if she had made these statements in school. Except that the school, one little wrinkle, there's always another wrinkle in the First Amendment, the school is saying that she had signed a waiver when she got involved in cheerleading and that the cheerleaders and other athletes understood that they could be punished for various things that other students couldn't be punished for. But the courts actually looked at the various things that were in the waiver and concluded that it was not clear that what she said would be covered. So the question goes up to the Supreme Court. It has two parts. And I said the school is appealing because they lost below in both courts. And the two questions are, first, can schools punish off-campus speech? And if so, what standard applies? And the second is, if that's the case, is the school justified in punishing this student for what she did?
Very good. Who wants to jump in? It's a very chilling effect to think that the schools can punish students for their speech outside of the school. What kind of effect is that going to have if that ever did happen?
Well, right. So the court in Tinker v. Des Moines School District, the case which announced this test, said, of course, First Amendment rights don't stop at the schoolhouse gate. But the school district's position, which in fact has been endorsed by most of the federal courts that have considered it, is they stop even before the schoolhouse gate. Even speech outside the schoolhouse gate can be punished if it leads to disruption on campus. The problem, of course, is that these days, especially with online speech, but also with online broadcasts of offline speech, a wide range of speech can cause disruption. Somebody posting something on his webpage, or somebody saying something at a political rally that is then live streamed, or somebody saying something in church, or even writing a letter to the editor of the newspaper, which is then posted online. And even if it's not posted online, it's read by other students and could lead to maybe fights or other disruption in school. So if all one focuses on is the school's interest in preventing disruption, then a school would indeed have 24/7 control over any sufficiently controversial speech by students. Now, the complicating factor, I think, and I'm not sure, but I suspect the justices are going to be concerned about this, is there are certain kinds of speech that when set offline are going to cause so much trouble at school that there's some sympathy, I expect, on the court to allow such restrictions. So one example might be what some people call bullying or harassment. I don't like those terms because they're not well defined, but they sound that way. So I prefer a term that is also not well defined, but at least is pretty clearly not well defined, is personal cruelty. So somebody posting nasty messages about a classmate, calling her fat or a slut or something like that. Lots of cases like that. And I think the justices are going to want to see, I suspect, some way of authorizing the school to restrict such speech, partly because such speech really does affect the environment at school, and partly because I think that say, look, if adults say it to each other off of campus, that may be constitutionally protected, but it's not the sort of speech that really most care about. So I think it may make sense for the court to say, look, generally speaking, off-campus speech, and off-campus is shorthand here for outside of school programs. Obviously, if there's a Zoom class, the fact that you say something for that class from your bedroom doesn't make it off-campus. But let's set that aside. Let's just use off-campus as shorthand for outside of school programs. That off-campus speech should be constitutionally protected, unless maybe it falls within certain exceptions, just like the court has developed some exceptions to free speech protection in other areas like libel and obscenity and such. So maybe, for example, this kind of personal cruelty, maybe certain kinds of borderline threats. Now, of course, true threats of violence, I'm going to go and shoot up the school, are already unprotected. You could go to jail for them. You can go to jail if you're not a student for them. So it's not, they don't just stem from the school's authority over its students, but perhaps you could imagine a court saying, well, things that are kind of borderline, things that probably in context aren't intended to be threatening, but cause a lot of interference with the school. Maybe school is canceled for a day or something like that. That should be punishable as well. I can see the justices, rightly or wrongly even. I mean, you could debate whether they should or they shouldn't, but I can certainly see the justices wanting to find some way of authorizing certain very narrow exceptions like that. I just don't want to see the court say, oh, the way we'll deal with that is just by saying any disruptive speech, including off-campus disruptive speech, is going to be punishable, because then again, that could just extend to political advocacy, to people saying things on controversial matters related to race or sexual orientation or sex or immigration or whatever else. That would be 24/7 control over junior high school, even elementary school student speech.
I want to leave room for David to pitch in, but I would like to respond to a couple of things that Eugene said before we forget what he said. So the first is, I take a different view of what the other circuits that have reached this question have decided. About half the circuits have never considered this question at all. And most of the rest have used what I would call sort of tinker plus. In other words, the school needs to show a pretty close nexus between its concern, some circumstance that involved, if not a true threat, something that looked pretty scary, like a drawing of a teacher with a gun to his head. The Ninth Circuit expressly said, if it's going to be, not just the kind of disruption schools always claim under Tinker, because they've really pushed this to the limit. And in this case, in the trial court, the school district didn't even say they anticipated disruption. They just said it violated our regulations. And a lot of girls on the cheerleading squad were, upset. That's not material disorder. That's hurt feelings. So the Fifth Circuit took the most permissive view, and the Supreme Court declined to grant certiorari in that case. In other words, they didn't want to hear that appeal. So when they granted cert and said, we'll hear the appeal in BL, the Mahanoy, if I'm getting it right, that raised alarm bells for everyone who cares about freedom of expression generally, and for students, because school is where students learn how to exercise First Amendment rights. And here they're getting the message, you could be watched 24/7. So that is an issue when we talk about what the material disorder standard actually has become on a slippery slope to very loose allegations by school authorities. And then in terms of personal cruelty, I think it is very clear, and the lawyers for BL and her family have conceded that schools absolutely can reach out to off-campus speech that threatens either, violence at school, serious bullying at school, and things that rise to a legal level of harassment, which is not just anything that makes somebody feel bad. It's a pattern of verbal and other kinds of intrusive assault. I don't mean physical assault, but that really goes after somebody in a targeted way. And that's not one web posting that I hate someone or someone is fat. So when you get to off-campus speech where people are engaging in that way, we might not like it. Parents might say, I don't want my kid acting cruel. I'm going to punish them. I'm going to ground them for these tweets. That is very different from the state in the form of school authorities punishing people and also putting that discipline on their permanent record, which has serious repercussions, which can, if it's a suspension, we have a lot of research that shows that can lead kids on the school to prison pipeline. These are serious issues. This is not like being told you can't drive for a week. And it can affect your ability to enlist in the military, get into college, get a scholarship, all of those things. So I think personal cruelty is quite controversial. And I think it's very hard to define in a way that kids would really be on notice about what they could and could not say, because outside of school, and as Jean said, for adults, you can call people all kinds of names. We might not like it, but what the schools should be doing instead of punishing people is teaching them. If you have an off-campus incident like that has made its way into school by virtue of being reported by other students, not by the speaker. Of course, you can punish the speaker if they bring it into school. But a lot of these cases, like this case, other people told the coaches, oh, I took a screenshot. Look what she said. So you can call the class together, you can call the team together and say, let's talk about what's wrong with this kind of speech and how we should deal with each other. That is what schools are for, in my opinion.
David, go ahead.
Well, I agree with both my colleagues. Obviously, it's a similarly important case. Right now, we're in an environment where public school officials, parents, and students really don't know where the line is. And it certainly it does have a tremendous chilling effect on speech. I've personally been involved in a few cases where school officials really didn't know what to do. They didn't know the extent of their authority under this. It's something that up until now, the U.S. Supreme Court has assiduously avoided various petitions for writs of certiorari that have come up. So I'm actually, at least from an intellectual standpoint, I'm fascinated that the court's taken the case. I kind of fear what the court might do, but we'll see. But it's certainly fascinating. I think what's also interesting is that the Tinker, which was decided back in February of 1969. We've had this Tinker rule for over 50 years.
60.
Yeah, well, yeah.
So forgive my math. I'm so off, or I'm so old. I don't know.
We've had it for 51.
So I can say with great confidence that the Tinker rule has been here 52 years.
Oh, thank you, Jim.
February
2021,
1969 was the date of the decision.
If you agree with nothing else I say, I feel you can take this to the bank.
And what is interesting is you read the Tinker opinion by Justice Abe Fortas. It's a very student protective opinion. It reads like a paean to student expression. And what's been interesting is how courts have essentially taken that pro student speech ruling largely, and I think have expanded outward what is a reasonable forecast of a substantial disruption. And so a speech protective standard has become almost a speech inhibiting standard in a way. because some courts have taken a very, very broad, expansive view of what constitutes a reasonable forecast of a substantial disruption. So that's also of concern.
Well, disruptive doesn't really mean it's not important or valuable. Anything that's going to change the status quo is likely to be disruptive.
And that's what Justice Ford has said. He talks about hazardous freedom. He says we often have to take risks in a constitutional democracy, right? I mean, the entire opinion, almost other than the line about we have to interpret the rights in light of the special characteristics of the school environment, almost the entire opinion is very much a pro-student speech opinion. And as my colleagues have said, the court since then, every time it's taken a student speech case, has chipped away at it a bit. It did so in Bethel School District versus Frazier in 1986, saying public school officials can prohibit student speech that is vulgar or lewd. They originally also said plainly offensive, though Chief Justice Roberts cut back on that a little bit in Morse versus Frederick in 2007. 2 years later, in 1988, in Hazelwood School District versus Kuhlmeyer, the court created a new standard for so-called school-sponsored student speech. When they said educators do not offend the First Amendment by exercising editorial control of the style and content of school-sponsored expressive activity, essentially when they have something that's reasonably related to a legitimate pedagogical concern. That's a rational basis standard. And that was the holy trinity of student speech law for a long time, was Tinker, Frazier, and Hazelwood. And then nearly 20 years later, we get Bong Hits for Jesus and in Morse v. Frederick. We even had a justice, Justice Thomas, who actually argued that Tinker should be overruled. So we'll see. It's really, really interesting. The court doesn't take these K through 12 student speech cases very often. That's why we're all very, very much interested and concerned.
There's another really important thing about the Morse case, which was the one in which the court held that schools could regulate illegal substance speech that was not political. So in other words, positive speech about drugs and misuse of alcohol. But in that opinion, Chief Justice Roberts said he didn't even know what the Frazier standard meant. And the fifth vote for the holding came in an opinion that said expressly, I'm concurring, but this is as far as we can go in allowing the school to regulate off-campus speech. So what were the facts there? During the school day, the school in Anchorage, Alaska, had said the Olympic relay parade is coming through town. This is a big deal. Nothing ever happens here. We're going to let all the students go across the street and watch this Olympic event under the supervision of teachers and staff. And so the question was, is this in-school speech or is this out-of-school speech? And using Eugene's definition, which I think is perfectly right, in-school speech includes things like you're on a school trip. So it wasn't, from my point of view, very controversial that this was in-school speech. And yet one of the justices said expressly, I won't go further than this in allowing the school to reach kids off campus and regulate their speech. So that's another reason why it's concerning that they agreed to look at this case, which would be a vast expansion beyond the kind of school of speech that was at issue under the facts in Morse. And the other side of that is that the line between off-campus and in-school speech is important because there's another aspect to the special environment of the schools. And there's a lot of disagreement about whether parents fully have turned over their authority when they send their children to public school. But there is no disagreement that by choosing to use a public school, parents do not give their parental interest in their children up. And that is one of the oldest fundamental interests that the Supreme Court has recognized, that parents have a due process, a substantive due process, liberty interest in the care, custody, and control of their children, and a right to inculcate their children with the values that they hold dear in their family. So this reaching out by the schools to discipline speech on a weekend, no contact with the school at all, no involvement on personal equipment, not on the school's, online network, interferes with parents' control. So we have sort of divided the week up. We've got the school hours and the extracurriculars that the parents have consented to. That's on the school. And the rest of children's lives is under the supervision and modeling that their parents choose. And I think that is something that the school authorities and many of the educational groups supporting the school district have really lost sight of.
David, Eugene, feel free.
Well, the other thing I would say is that, we often view Tinker through the lens of the substantial disruption part. But as my colleagues have said, there's that other part, interference with the rights of others or invasion of the rights of others. And since we live sort of in the age of cyberbullying, perhaps the court might address that sort of oft forgotten part of Tinker. When exactly does student speech interfere with rights of others?
Oh, if I could.
So I think that this is something that needs to be talked about. I have to say, I know a lot of people like to use the terms harassment and cyberbullying. I think that they do more harm than good. So for harassment, for example, in the school context, usually is defined as speech that is, quote, severe or pervasive, or perhaps severe and pervasive, depending whom you listen to, enough to create a hostile, abusive, or offensive work environment, or educational environment in that context. What exactly does that mean? One thing that's pretty clear is it isn't limited to personal insults. It could include political advocacy. So I suppose somebody could say that this person, by going to some anti-gay rights rally or some anti-illegal alien rally or some KKK rally, they're creating a hostile environment on campus just by showing up, because classmates are going to be very upset at knowing there's this person who hates them among them. Under normal definitions of, is it severe enough? Is it pervasive? Well, they're going to be there all the time, and maybe they're going to say these things offline often. Does it create an abusive or offensive environment? Well, maybe. Nothing in that definition excludes political advocacy. And in fact, in the context where we've seen this discussed most, which is in the workplace, where there's a similar hostile work environment, harassment policy, I've seen cases which say that displaying the Confederate flag, for example, creates a hostile environment. And note, again, we're talking here not just about speech on campus, but in principle, you can imagine someone going around in town wearing a T-shirt with a Confederate flag. Even if they don't bring it to school, somebody might say that that's harassment at school because it creates this environment. Now, the thing is, harassment, of course, has other meanings. So in the criminal context, there's a definition of criminal harassment that began with telephone harassment, but now is extended to online speech. I just filed an amicus brief in one such case in Ohio where a woman was being criminally prosecuted for criminal harassment because she was posting a lot of things that were sharply critical of a manager at the nursing home where her mother lived shortly before the mother died. She thought that the manager was and the nursing home were responsible in part for the mother's death. She started posting all these things. Instead of the manager suing for defamation, the manager got her criminally prosecuted, and the prosecutor brought charges that were then dropped on procedural grounds. So I think the word harassment is not a particularly good term, but it sounds good. That's the problem. It sounds like it's well defined, but it's not. Likewise with cyberbullying. I've filed amicus briefs in a friend of the court briefs in a bunch of cases trying to get struck down various state harassment and cyberbullying statutes with some success, because again, often they're defined so broadly as to be unconstitutional. whatever the test, you can call it personal cruelty or whatever else. I think the important thing is that any exception for off-campus speech has to be focused on things that are personalized, things that are about a particular person by name or by pretty unique reference, not about Catholics generally, or Trump voters generally, or conservative Christians generally, or illegal aliens generally, or blacks or whites or Jews generally. And unfortunately, the words harassment and cyberbullying don't have that element of personalization clearly present there. So whatever
I agree
I want to
that
make sure that it focuses on that.
they can be very vague, but the examples that Eugene just gave are really helpful to people trying to understand this whole area, because one of the absolute sins under the First Amendment is viewpoint discrimination. And the examples Eugene was giving of somebody who has anti-gay or pro-gay or strong political views, that many of these cases underneath a claim that people at the school are feeling hurt is condemnation of the viewpoint expressed by the person being accused of harassment. And then in talking about it has to be specific and targeted, I agree that saying generally, and I'm choosing this from the cases, not making it up, all gay people are going to hell is one kind of statement, comes from religion, as well as several First Amendment interests. But you are going to hell. Your brother who's gay is going to hell. That is much more targeted and fits more within the framework that Eugene is suggesting. But there's another irony about these statutes and about the school's position about bullying, because until these recent cyberbullying cases and the very large number of states that have made schools responsible for off-campus cyberbullying, as well as other sorts of bullying, not online, outside of the school day, which the schools really don't have the resources to do, even if they want to do that. That's a different issue. But before that, most of the cases about bullying involved parents who sued schools, or people who turned 18 and sued schools for not protecting them from horrible, really shocking levels of bullying, not just verbal, but severe physical violence. And the question there was whether the violence and the bullying had reached the level of severity and pervasiveness that created such a hostile environment the student could not get an education. And in all of those cases, the school's posture was, oh, it wasn't that bad. We weren't required to do anything. We can't be held liable. So this is an ironic and very disturbing turnaround from schools that kept saying, oh yeah, I knew about it, but I really had no legal obligation to protect this young person, to now saying, I want to extend my disciplinary powers outside the walls of my school, where I haven't been willing to take responsibility and punish people. I find that very troubling.
I appreciate your point, I think, but is it really the same schools that?
I know it's not the same schools.
Well, but why is it a turnaround? It just sounds like there are some schools that take a pretty relaxed view and some schools that take too aggressive a view, right?
No, it's the patterns of the legal cases that have been coming up. So we had a period where all of the litigation was the schools saying, we're not responsible, and the courts saying, you're right. You're not liable for taking care of people who are being bullied. And now we've done a pivot, and the question is framed differently, and the answer is different. And nobody has really connected those two lines of cases. No, of course, it's not the same schools. That would be, it could happen, but it would be unusual in, the 100,000 or whatever school districts that there are. But it's the pattern of the legal questions that were coming up at different times and how they were resolved. And they don't seem to me reconcilable.
Another point where this comes up, for example, is that there have been instances, I've heard anecdotally, where students are having class virtually, and in the background, one student has a Trump poster or picture, and other students complain to the teacher and tell them essentially that picture of Donald Trump causes them psychic harm, and it's interfering with their ability to learn.
Yep.
And that's the type of stuff that I think is very dangerous, right, from a First Amendment perspective, where it leads to the censorship of pure political speech. And
right. So that, I think, is a problem that goes beyond this case, because in class it really is in school speech, more or less. And the weird thing about the Tinker test is that it essentially has been read to allow what is sometimes called a heckler's veto, even though it's rejected in other contexts. So a classic case of that is one called Dariano from the Ninth Circuit, where there was a school in California where it routinely had a Cinco de Mayo celebration, which I think a lot of the Hispanic students appreciated because it was linked to their culture. And there were some students, including one Hispanic as it happens, who wore American flag t-shirts on that day, maybe just to tweak people's noses, but the part of it was probably also the message that, I'm more interested in kind of affirming and people affirming their American nationality than their broader ethnic bonds. So that had apparently led to some threats of violence, maybe some scuffles in the past. So the school said, you may not wear an American flag t-shirt to school. Why? Because somebody might start a fight. And the Ninth Circuit upheld that. Of course, outside of school, that would be a classic heckler's veto situation, that the government is trying to suppress speech because a heckler, somebody who is upset with it and who threatens to fight over it, is threatening to fight. And the answer outside of school is you've got to shut down the heckler and not the speaker, or protect the speaker against the heckler. The police, if they're there, they need to say to the heckler, if you actually do attack the speaker, we're going to arrest you, and not take away the speaker because he's provoking people. But in the school context, unfortunately, this heckler's veto has been approved on the theory, not implausible given the language of Tinker, that sometimes this threatened violence does cause substantial disruption. And if that's the standard, then such speech can be restricted. Now, to be sure, I think there are times when the substantial disruption is chiefly mythical. So indeed, if this is somebody's Trump poster at home, in a virtual class where nobody gets to throw a fight, or start a fight, nobody's going to throw a punch. At worst, some students are going to say something, and then the teacher can step in and say, look, folks, just focus on what on the class discussion. I think such speech, whether it's an American flag or a Trump poster or an anti-Trump poster or whatever, it should be protected, unless, of course, the school wants to say we don't want any kind of disruption. So it doesn't matter if it's a Black Lives Matter poster or a Trump poster or any other poster. We don't want any distraction. You need to have, as a sort of a content neutral rule, you need to have a clear text-free background. That I could imagine. But as it is, it sounds like viewpoint discrimination based on people's hostility to certain viewpoints that would normally be not allowed. But regardless of how this case comes out about outside campus speech, it does involve in school or in school program speech. And under Tinker, there has been a lot of tolerance for that kind of speech being restricted.
And that's a shame, right? Because Tinker itself, in a way, can be seen as a case that stands for the principle there shouldn't be viewpoint discrimination, because school officials selectively targeted a particular symbol associated with a particular viewpoint. And in Tinker itself, students were allowed to wear iron crosses and political campaign buttons, and it was only the black armband that got targeted. So the Tinker case itself should not stand for viewpoint discrimination.
And Tinker also indicated that the heckler's veto is not permissible, that the disruption that is anticipated has to be attributable to the speaker, because one of the few ideas that the school finally came up with very late in the game for saying that there might have been disruption. They said there were a whole bunch of students who were upset about the black armbands as part of the Vietnam War, demonstration against the Vietnam War. And they said, but that's not an adequate excuse for silencing the speaker. And that's a very important footnote in Tinker. So Eugene is absolutely right. There are a whole string of cases in which schools have allowed the heckler's veto, but those cases are wrongly decided. We shouldn't say, we don't have a Supreme Court decision about that. And there is a lot in the early jurisprudence and in the Fifth Circuit cases that preceded Tinker, from which Justice Fortas adapted what became the Tinker standard, say very clearly that the speakers in school cannot be blamed for what other people do in response to their speech. We have to be able to attribute that disruption to the speakers in order to punish them. So I think that is you're right that it's out there, but it's a real distortion of the law. And it's one that really should be corrected. I'm not saying I have confidence that the courts will correct it, but it's wrong.
David mentioned, there seems to be a gradual erosion of rights to free expression and free speech. Is that part of a larger cultural shift away from individualism towards collectivism? What is it that's driving all these attacks on free expression?
To be fair, the attempt at schools to punish student speech is not new. It's been around throughout American history, at least as best I can tell. It was certainly around in Tinker, but I don't think Tinker was a weird outlier. Everybody else was all on top of high school kids, or all open to high school kids saying whatever they want to say in just this Des Moines school district. And since then, of course, many schools have tried to restrict speech in various ways. Plus, also the speech here, it's fuck the school, fuck cheer. It's not exactly the sort of thing that I think many schools see as something that really badly needs protection, especially given the facts of this case, which is that what happened to the girl, she got kicked off the cheerleading team. So you could imagine an argument that this is all about kind of morale and esprit de corps on the particular team, and that the focus should be on that. It's just that's not the way this case has been litigated. The question that is now before the court is, does the Tinker standard apply to off-campus speech? And not does the Tinker standard apply to speech that, or what standard should apply to speech that is seen by the school as damaging esprit de corps on a team, and as therefore justifying removal of the student from just that particular team. So I do think there are a lot of problems having to do with free speech in the country as a whole. I do think that people have become a lot less tolerant of certain kinds of things in certain kind of contexts. But I don't think this is that there's a marked change in how schools that used to be all in favor of protecting student speech now are all in favor of restricting it. I think that schools have been into restricting speech by and large in lots of situations. The one thing, of course, is that technology means a lot more such speech comes to their attention. That before, a lot of the speech would have just been conversations, and somebody goes to the principal and says, "Principal or coach, this student off campus at a party said this offensive thing," and the coach says, "I don't want to have to decide what she said and whether she said it, so don't bother me." But now that it's all in writing, it makes it a lot easier for schools to punish people for it, and also just makes it much more likely that it will come up to the school where in a situation where they feel we need to do something. Even if they'd rather not do anything at all, they feel we need to do something because otherwise it'll look bad.
Mike, Justice Fortas in Tinker said that schools are not, quote, enclaves with totalitarianism, but the reality is that they often are. And the disconnect that I see from the First Amendment ideal and the real is that one of the most foundational free speech principles that we have in our jurisprudence is that the First Amendment gives us the ability to criticize government officials, right? That's the essence of Times v. Sullivan and a long line of Supreme Court precedent. But in the school context, if a student criticizes the principal or criticizes a teacher, they often get into trouble, constitutional doctrine aside. And so I would just reaffirm or concur with what Eugene's saying, that there's almost always been this idea that students don't have the ability to speak out, that there's always been this culture of censorship that pervades, at least in the K through 12 environment. And so it's just a climate of censorship that we're constantly battling in this arena.
Mike, I'm sorry. I think it's 3 o'clock, at least 3 o'clock Pacific time, and I have to go. Okay. So I don't want to. So I leave things to my colleagues, who I'm sure will do a great job of covering all the issues. And Catherine, if you want to chat further, just drop me an email.
I will. That'd be great.
Thank you so much, Eugene.
Thank you.
David and Catherine, you want to continue a little bit, or shall we?
I had one thing I'd like to add, and I don't leave my house, so I got time. So sad. I really loved the question that you posed about collectivism versus individualism. And I would like to suggest that would be a topic for another conversation, because we could not begin to do justice to it in what time we have remaining.
Okay.
But I wanted to raise another big picture question about this case, which is that the Roberts Court has a pattern of considering questions that go far beyond the case in controversy that is brought before it in an appeal. And they've made some of their biggest decisions in that way. And I think this case, whatever the court ends up holding, we could be wrong. They could protect student rights. I don't know. But this case, first of all, I don't think they should have granted cert, because or if they granted cert, they should have restricted it to reverse the question and say, could this speech have been punished in school under Tinker? Because if not, then we don't have to ask whether they can punish it off campus. And that's also why they should have not granted cert, because it seems so clear that it couldn't be punished in school. And the school didn't make a credible argument that there was any risk of material disruption. In fact, at trial, the counsel for the school said, no, we didn't really anticipate disruption at school. So this is just, you should have just left this out of court.
I agree. What are your thoughts, David?
Yeah, I'm concerned, right? Because as Catherine said very early on, right, the Third Circuit has a history of being fairly protective of student speech, at least with the Layshock and the Blue Mountain School District case back in 2011, I think it was. And the Roberts Court, for example,
for people who take free speech rights seriously, this is very scary.
The Roberts Court in certain areas has been protective of free speech. But if you look at public school students, public employees, and prisoners, there's a separate body of First Amendment law for each one of those. And in each of those areas, the Roberts Court ultimately has come down against the individual in favor of the government. They did so in Morse versus Frederick for public school students. They did so in Garcetti versus Ceballos for public employees. And they did so in Beard versus Banks with regard to prisoners. We did get that little nugget that Catherine mentioned when Chief Justice Roberts said the argument that public school officials could prohibit speech because it's plainly offensive. Roberts said, I think that stretches Frazier too far. But I'm concerned on what the court is going to do here, and I think that I'm just thrilled that she's writing an amicus brief and that you're having programs about it, because it's a really timely and incredibly important topic.
David, I hadn't made that link among that that line of cases in different institutional settings. And that is such an important insight. Thank you for that. And it is also, I think, something the school district is very aware of, because the school district's briefs use the example of schools on military bases.
Yet another area, the fourth area.
Yeah, and they specifically say that on military bases, the schools have much broader authority. And they do in a variety of ways. For one thing, they can call the parents in any time and say, you know, you have to get your kids in line, not just about speech. And the parents have to do that because that's their employer. But I had not connected that line of argument for the school district here to those other institutional cases. And they're clearly, they have something in mind that they think will appeal to the court there.
Yeah, and in fairness, they did slightly cut back on Garcetti and Lane v. Franks,
Yes.
where they said that the First Amendment protected a public employee's right to give truthful in-court testimony. But Garcetti v. Ceballos, I think, is just an awful, awful, awful First Amendment ruling. And I hope that they don't do further damage to the student speech area. I think they all need to read Lessons in Censorship, your book. That would be good.
Thank you. Thank you. It's a joy to be here with you, David.
Well, I wanted to thank both of you very much, David, Catherine. I'm going to take your suggestion. Actually, I think we could do a whole hour talk on collectivism versus individualism in terms of you know, the effects on free speech. So I'd love to have you both back on at some point.
Thank you. That would be really fun. This was a great conversation.
I enjoyed it immensely. Thank you.
And it's nice to be face to face with you after all these years.
Will this be posted on YouTube or something? Is that?
Well, I have a YouTube channel and a number of other channels. I already have 2 strikes on my YouTube channel for medical misinformation. So don't like when you talk about COVID or anything like that. Like, any kind of dissenting opinion, just like they zap it right away.
Oh
Yeah.
dear. So you'll send us a link, I assume.
I definitely will.
And because we had some sort of informal back and forth there, do you edit this in some way?
Yeah, no, just to begin, it'll mostly be posted as is. I'll just do an introduction and then just chop off the end here that we're having a little chit chat, right?
Okay.
But aside from that, it'll just go straight up. There's not going to be much editing at all.
So I knew you wouldn't do editing in the form of censorship.
That would be pretty sad.
Thank you so much.
No, thank you both very much. I appreciate it. And I'll be in touch with both of you. Hopefully we can set up another time.
Wow, you're a fast worker.
Can we do one when the decision comes out? Maybe?
Absolutely, 100%. And if you have topics you want to talk about, just shoot me.
Okay.
You know, I'm happy to, you know, consider it and work it in. I'm sure we can.
Thanks so much.
Wonderful. Take care. Keep in touch, David.
Okay, I'd love to. Love to.
Thank you so much.
Bye, everybody.